Hey everybody, welcome back. Hope you had a great week. I'm sorry I didn't get to meet with you in person last week. I had some things go on, but I'm glad I can be here with you this week. And I was really proud of the work that I've seen done in this class. What I've seen has been exceptional. I want y'all to keep up the great work. One thing I will say is try not to fall behind. It's a 4 week class. There's not much time to catch up, so just be careful with that. Last week, I want to start with a little bit of recap because we didn't really meet last week much, and because it's just a good way to springboard into what we're talking about today. But last week, we spent a lot of time talking about the foundational stuff of criminal law, the things you really need to understand and know about to make the rest of this stuff make sense. And we talked about things like what is a criminal law, what elements need to be present for criminal law to be considered valid or enforceable. Things like where do criminal laws come from? Why do we have them? Are they really doing anything good for society? Should we have them at all? So we spent a lot of time talking about that kind of stuff and some other things to get us ready to talk about the things we're going to talk as we progress through this class. And today we move into one of the more weightier buckets of information in this class, and that is the idea of defenses to criminal liability. Now, a lot of you might be thinking, why do I need to learn this? Unless I'm going to be a defense attorney or prosecutor, why do I need to know this? This is important information no matter where you're at in the spectrum. For one thing, you might be a prosecutor or defense attorney in the future. We've had students who wanted to go to law school out of this program. But no matter where you're at in the criminal justice system, these principles are important to you, and I'm going to explain why right here. Number one, it's important to you because I may check off all those boxes we talked about last week in committing a crime. I may have done every action perfect for you to prosecute me for breaking that law. Yet I may not be prosecutable. You may not be successful in doing that, and there may not be any reason to prosecute me because I never intended to commit a crime. Okay. Let's say, for example, I'm sitting around with a bunch of friends. We're all sitting there. 2 or 3 of us are cleaning our guns. My gun goes off. I've done all the safety measures you were supposed to do, but an accident occurred. Nobody's fault. And it shot this other person in the arm. Now, technically, I just assaulted this person with a gun. So assault with a deadly weapon. But you can't prosecute me for that successfully because it was an accident. We were all sitting around doing this, engaging in this behavior, and it accidentally went off. I didn't intend to shoot anybody. I didn't go in there to shoot anybody. It was just a complete accident. And so the law says I can't be prosecuted for that. So even though I've checked all the boxes, done all the actions, I brought a gun to the house, I shot somebody, I did everything I was supposed to do, I still didn't have the intent to be able to be prosecuted for that. So that's the first one. It helps us determine whether or not we have a case. Second thing that it's important for is eventually when you prosecute someone, they're going to get a defense attorney in most circumstances unless they waive their right. But most people who have any sense aren't going to waive their right to a defense attorney. So this defense attorney is going to do what they're supposed to do, look out for the rights of their client. That's their constitutional duty. That's their job in the criminal justice system. And part of that is developing a good defense for what the prosecution is bringing forward. To be able to say, first off, either the evidence isn't there, but if they're going to go with a defense to criminal liability, these are the reasons why this person should not be charged for this crime or should get a lesser sentence because there is an excuse, a justification for the actions they engaged in. And that justification may be enough to dismiss the case or do a whole bunch of other things we're going to talk about. Now, we use a lot of technical terms in the criminal justice system. Every, career field in the world does. And a lot of times these complex, crazy words have pretty simple meanings when you break them down. And liability is one of those. When you think about liability, the best way to think about it at first pass is liability is basically how much responsibility you hold criminally for the action that you engaged in. So, yeah, you did the action. Yeah, you checked all the boxes. You committed the crime. But you still shouldn't be held either criminally responsible or as criminally responsible because there's a circumstance there that needs to be weighted in as well. Was it something to do with mental illness? Was it a self-defense? There was some reason why you did it that it makes a good justification that keeps you from holding total or complete liability for this criminal action. So important to the idea of criminal liability specifically is the idea of intent. And intent sounds like it's everything it sounds like it is. Intent just means how much did you intend to break this crime? Now, it's not talking about ignorance of the law. It's two different things. Ignorance of the law is I didn't know these laws existed. I didn't understand the wording of the law, that kind of stuff. When we talk about intent, we're talking about how much did you intend to go in there and commit a crime, to do something wrong, to do something illegal. And the law says you have to have a certain amount of intent. Otherwise, mistakes like I talked about with the gun cleaning incident would be prosecutable. Because I checked all the boxes, I brought a gun in, I shot a guy, but I never intended to hurt anybody. Now, there's different levels of intent. It's not all the same. The first one is the highest level of intent. That's basically intentional, purposeful. I meant to do what I did. I say I go out and rob a bank, and you have evidence of me plotting to rob this bank. I have done surveillance. I know where all the security cameras are. I know when the best time to rob this bank is. I went in, I bought all kinds of materials and weapons and whatever I had to do to make a run at robbing this bank hopefully successful for me. And I go in and I rob this bank. It's pretty hard to argue I didn't intentionally do that at that point. Okay, I went in there with the forethought and the knowledge and intentionally wanted to rob this bank. That's intentional. That's the highest level of intent. But the law says that not all crimes require me to reach that level of intent. That sometimes intent can mean something smaller. An example of that would be knowingly. I engage in a behavior that a reasonable person, and you're going to hear this reasonable person standard a ton of times when we talk about criminal law, criminal procedure especially. Reasonable person just means that a reasonable average person on the street, this is what they would think. This is what they would understand to be true. Okay, that's all it means is taking generic person A off the street, just randomly grabbing somebody. This is the knowledge they'll have at that moment. So a reasonable person off the street would say that if I engage in this behavior, somebody's probably going to get hurt or killed. Some crime's probably going to result. So, for example, one example comes to my mind from several years ago is I remember there were some teenagers who were on this overpass, and they were throwing big rocks over onto the interstate below. So you got cars coming 70 plus miles an hour or whatever down the interstate, and big rocks falling on them from above that they're not expecting. Now, a reasonable person, I think most of us would say, something bad's probably going to happen if you do that. And sure enough, somebody wrecked and got killed. In the process, of course, the defense argued that they didn't intentionally go out and hurt anybody. These kids were out doing something stupid. We all agree with that. But they weren't trying to kill anybody. They didn't go out there and say, all right, we're going to kill somebody today. But they did act knowingly. They did act in a way where anybody engaging in that action should know, a reasonable person would know, is going to end in injury or death, or have a high probability to. Now, sometimes we can go a little bit lower than that, and we got what we call reckless. Reckless just means that I consciously disregard the risk associated with the actions I'm about to engage in and do something that has a high probability of someone getting hurt. So, for example, let's say I'm in a hurry and I'm speeding down the road. I got an appointment, whatever, and I'm trying to make it. And the light turns red, and I don't really see anybody coming, but I just keep going. And out of the side, somebody pulls out, and because they got the green light, and I hit them, and they die as a result of that. Then I can be prosecuted. I didn't intentionally kill this person. I didn't go out and say, I'm going to run this red light and hurt somebody. I didn't even knowingly do it because people run red lights all the time and people don't die. The odds aren't like 80, 90% that if I run this red light, somebody's going to die. But it's really reckless. Any normal individual, again, reasonable person on the street would say that's pretty reckless. Somebody can get killed. And you're disregarding that and continuing to go through with the action. Therefore, I can be prosecuted for that. The next one we have is called neglect. Now, sometimes it gets really hard to tell reckless from neglect. The best way to really describe it is reckless is a conscious disregard for the substantial risks that exist in the actions you're about to take. So you just disregarded the risk that someone could die by running that red light. In neglect, it has more to do with failure to perceive that risk or understand that risk that should have been obvious to any person on the street. Any reasonable person would have known there was a risk associated with your action, but you didn't recognize it in the moment, but you could still be held criminally liable because you should have known. Let me give you an example of neglect. Let's say I go out to a bar and I have a bunch of drinks and I get lit and I get behind the wheel of my car. Now I'm drunk. I've drove home drunk in this scenario, not in real life, but in this scenario countless times, and I've never really had a problem, never gotten a wreck, never hurt anybody. I don't see a risk associated with me doing this. I convince myself, and I've worked with several people who have had DUIs and things, and this is not an uncommon thing to hear. I drive better when I'm high. I drive better when I'm drunk because I'm so conscious about it because I'm so nervous I'm going to get pulled over. I'm actually overly conscious and I pay more attention. I'm a better driver in that scenario, which is complete crap. But some people believe that. So I get behind the wheel. I think I'm a better driver. I drive. I wreck. I kill someone. I can still be charged for vehicular homicide because the reasonable person on the street would have been able to recognize the risk associated with that action, even though I didn't understand it. It was there, and it should have been apparent to me as a normal functioning adult in society. The last one we have are what's called strict liability. Strict liability cases just says we don't really need intent. You committing the actions, checking the boxes, that's intent enough. For instance, if you're driving down the road and the police pull you over and you give them consent to search your car and they find some drugs in the console of that car, you can be charged with that. Now, you may not know those drugs, have known those drugs were there. They may have been left by someone you loaned the car to or a sibling or who knows who else. But you are responsible for it. The cop doesn't have to prove that you knew they were there, that you intended for them to be there, that you did anything neglectful, or that you should have looked in the compartment or anything like that. The mere fact that they were there is enough under strict liability laws for you to be prosecuted. And those are really the levels of intent. And those are important because, again, it gets to how serious the charges are going to be and some possible justifications to at least mitigate some of the criminal liability. Another type of liability we have is something called vicarious liability. And vicarious is another one of those big words, which just means relatable liability. If somebody else commits a crime and I can be held responsible for, or at least somewhat responsible for that criminal action, based on the idea that you did something or you were in a position where you should have known what was going on and could have took steps to prevent that particular crime from occurring, or you took steps to allow the crime to occur. You gave safe haven to the crime. You did those kind of things. Um, Essentially, this comes into play a lot of times with like business owners. Someone uses their business for criminal enterprises, and the people above them were in a position they should have known that was going on. They should have fired them, done whatever. They can be held criminally responsible for those actions as well. What are some possible outcomes of a successful criminal defense by the defense team? The first one is you might be found not guilty. If the right defense is presented and it overturns any criminal liability in the case, then even though I checked all the boxes, I'm not guilty. I didn't break the law because I did not meet the intent necessary to commit the crime. It can result in a dismissal of charges if they can show that, look, under this defense, and here's the reasons why we have shown this defense, this person didn't actually meet the requirements of prosecution under this criminal statute, that their level of intent and liability has been shown to not come to the requirement of prosecuting this case, then the case can be dismissed. Sometimes you'll get reduced charges. I may not meet the threshold of intent or liability to be prosecuted with the level of crime that the prosecution has come with, and so they have to lessen the statute or the charges that are being brought against you so that you will meet that standard. A plea agreement, sometimes the defense will present a strong enough criminal defense that the prosecution will say, all right, let's do a plea agreement and get more favorable terms. Could mitigate the sentence so that even if you're convicted of the crime, you're not going to get charged. You're not going to have to serve the same amount of punishment for that crime because something has diminished your responsibility for that criminal act. And then sometimes you can get exonerated. And exoneration is another one of those big terms. It just means you've already been prosecuted, you've already been found guilty, you're in the justice system. Excuse me. Allergies are crazy. But you're getting out early because your prosecution's been overturned because of a successful defense to your criminal liability. So these are the outcomes that defense attorneys are really looking for when they come up with these defenses to criminal liability. Some popular criminal defenses. First one is self-defense. If I can show as a defense, and it's important to note that we have an adversarial justice system. When we're in the court system, it's a very adversarial system. I shouldn't say justice system, I should say court system. Where in a prosecution, the prosecution is trying to prove the state's case against the defendant, that the defendant committed the crime. The defense doesn't have to prove that he's innocent. It's up to the prosecution to prove that he's guilty. That switches when we talk about criminal defenses. In a defense to criminal liability, it's the defense responsibility to prove that their client meets one of these criminal defense criteria. And the prosecution doesn't have to prove that they do or they don't. It's the defense's responsibility to prove their defense. So self-defense is a big one. I shot someone, but they were breaking into my home with a gun and about to attack my child. That's a self-defense. Somebody's pointing a gun at my head, so I shot them first. Defense. Self-defense. Necessity, the idea that, I committed this crime. I'm not going to argue that in the court because the evidence is right there. Everybody knows that I did this. But I did it to prevent a worse harm from occurring. So, in other words, if I hadn't have committed this action that you say is criminal, something much worse would have happened. Take, for example, and this is just an example off the top of my head, someone is going to take a bomb into an area with thousands of people. And to prevent that, you assault them. I assaulted this person, but I did it out of necessity to keep them from blowing everybody else up. Duress, coercion, I committed this criminal act, but I did it because I was forced to. So in other words, and that doesn't mean, well, I didn't have no money, I had to go rob the bank. What that means is that I'm sitting outside, minding my own business. I'm waiting to pick up, say, my wife's getting off work or girlfriend or whatever, and I'm waiting for her to come across the street and get in the car. She's about to get off work. And all of a sudden, this guy jumps in the car with a big bag of stolen money, points a gun to my head and says, drive. Technically, I'm driving the getaway car, because I'm telling you right now, I'm not going to get shot over that if I can help it. But technically, I'm driving the getaway car. And when the police pull over, technically, I checked the boxes for breaking the law. I was involved in this criminal endeavor. I helped him try to get away. But my defense to that would be it was under duress. I was only doing it because he was holding a gun to my head and I didn't want to get killed. Another one would be an example, somebody holding your kid and you got a gun to your kid's head and tells you to go in and take some and steal money off of a corner store or something. Yeah, I technically committed a robbery, but I did it under duress, under an active threat. And most people, a reasonable person, would agree that a lot of people would have acted that way. That would be a successful defense. Defense of others, I was protecting someone else. Look, I was walking down the road and this 70-year-old woman was being robbed by this 30-year-old person, and I knock them over the head and I give her her purse back. And they say, well, you committed an assault. You hit this person over the head. Technically, they're correct. I assaulted this person. But I was defending other people. I was protecting this, I can't remember if it said 70 or 80, but I was protecting this elderly woman from being robbed, essentially. Another important key concept here is something called the Castle Doctrine. Most states have this. It goes back to case law from England and all that. Essentially says that a person's house is their castle. And you have a right to defend your house, your property. And so you have a lot more rights within your home. And that's true whether it be protecting it from people coming in and taking your stuff or police officers coming into your home. They have to get warrants, things like that. Your home is considered a sanctuary constitutionally and through legal tradition, Western legal tradition. And so if a person's breaking into your home, in most states you have a right to protect that home. Now, how that is defined differs by state. So don't think I'm telling you can shoot somebody that sticks their head through the door. In some states, you can't shoot someone unless you have no other choice. So in other words, someone breaks in your house or they're coming in, they're going to steal your stuff, they're armed. If there is a window upstairs where you and your kids and family can get out and run away to safety to the neighbor's house, you're legally required in those states to do that rather than actively engaging that person and shooting them. You can be arrested for shooting them because it wasn't self-defense because there was another way out. In other states, on the exact, way over on the other side of the spectrum, you've got some states with these stand your ground laws where, you can basically chase them. It really just depends on what the laws look like in your state, in your area. So I'd never tell you to take this and go, yeah, I can do it. No. The state's laws are very different from state to state. Remember from your intro class, we don't have a criminal justice system. We have 51 criminal justice systems. And that's the simplistic definition because the truth is we've also got systems in Puerto Rico and Guam, military systems. So, we have a lot of different criminal justice systems all operating at once, all having different definitions, different laws, different definitions of laws and requirements. So make sure that whatever state you're in, you check with the self-defense laws and Castle Doctrine of that state. But the idea generally of Castle Doctrine is you have more rights in protecting and being in your own home. It's kind of a sanctuary. One of the most popular defenses that people want to look at it, because it shows up in pop culture, shows up in movies and things so much, is the insanity defense. And I'll be honest with you, the insanity defense is not used nearly as much as people seem to think it is. I get students in my classes who think that this is like one of the top defenses that just get pop up. I guess. But it's not used as much as you think. It's not like it's never used, but not as much as you think, because there's a threshold you have to meet to prove that you meet the requirements for insanity. Most people think an insanity defense means I have a mental illness, therefore I escape criminal liability. And the truth is that's not at all true. There's people who have failed with their insanity defense who have severe mental illness, things like schizophrenia, bipolar disorder, and all kinds of, narcissistic personalities, all these things going on, and they still don't make the cut for insanity. And that's because insanity really focuses on what was your state of mind at the time you committed the crime? Did your mental illness or whatever was going on in your mind reduce your capacity so much that you were in a position where you couldn't help but commit this crime? Or there was no reason to stop yourself from committing this crime? Let me explain what that looks like in reality by talking about the 3 tests or 3 standards of insanity defense. These are the legal standards that have been set up through legal tradition in the United States. The first one, and by far the most used, is called the McNaughton Rule. The McNaughton Rule really focuses on how well you can understand the concepts of the wrongfulness of your actions and the gravity or weight associated with those actions. The best way to explain the McNaughton Rule is to think of it like, if you know a 4-year-old, whether you have one, you've got a brother or sister, you've been around a 4-year-old, if a 3 or 4-year-old grabbed a gun and shot somebody, most of us would say we can't prosecute the 3 or 4-year-old with shooting someone, because that 3 or 4-year-old, one, let's say they were just playing, they pick up a gun, they're used to picking up toy guns and they shoot somebody. That 3 or 4-year-old didn't know what they were doing was wrong. They picked up toy guns and shot them at people all the time. They didn't realize it was wrong, and they didn't understand completely that even if it was wrong, if they had been told they shouldn't do it because mom and dad told them you shouldn't be playing with guns or whatever, they didn't understand or aren't able to comprehend what the true consequences of that action could be. Like they don't understand that this is going to result in the complete end of the life of someone they care about. And so because they don't understand that it's wrong, and or that this action could result in death and serious consequences, most of us anyway, would say, never say all, but most of us would say we can't prosecute the 3 or 4-year-old. That's the same thing as McNaughton Rule. Only when your mental illness is so severe at the moment that you commit the crime that you're like that 4-year-old, in the sense that I can't understand that this action I'm doing is wrong, and I can't understand the consequences that are going to come from committing this action, not just to me, but to the victim and everybody else as well. That's the only time when a person can be considered under the McNaughton Rule to be criminally insane. That's a really high bar to meet if you think about it. And so that's why we don't use psychological defenses as much as people think. The second one is the Derman's Rule, which basically says, all right, you got this mental illness, but did that mental illness cause you to commit a crime? Was the crime committed as a direct result of your psychological problems? Were you compelled by the voices in your head to commit this crime? Whatever the case is. The third one is the irresistible impulse test. This is kind of a newer one in legalese. This test basically says, were you so compelled by the circumstances of your mental illness that you could not overcome the impulses to commit this crime? You couldn't control your actions. Your actions were uncontrollable in the moment, as a result of the irresistible impulses created by your mental illness. If you can't prove one of those three, and again, we have 51 different criminal justice systems. Different criminal justice systems use different rules, different tests. Most states fall under the McNaughton rule. That's pretty much the one that's won out. Entrapment. Entrapment's an interesting defense. It's actually one that's found in the U.S. Constitution. You can't be entrapped. Entrapment just means that the police or members of the criminal justice system can't trick you into doing something you wouldn't usually do just to prosecute you. You know, we can't trick you or force you to do something you wouldn't ordinarily do just so we can get evidence against you and prosecute you. And some people take that to mean, who don't really understand what entrapment is, to say, well, then how can they do drug buys? You know, you're sending a cop in there, undercover or someone, to buy drugs. Aren't you forcing me to sell drugs by coming up to me asking me to sell you some drugs? That's not entrapment. Because again, remember, entrapment is forcing you to do something you wouldn't ordinarily do. If I've been staking you out and I know you're a drug dealer, and I send someone in to buy drugs, I'm just having you engage in behavior you're doing all the time anyway. I'm not forcing you or trick you into doing something that's not in your character to do. That's not entrapment. Same thing with people who think that entrapment is police officers sitting on the side of the road in like a weeded area or somewhere it's not got a lot of visibility to catch speeders. That's not entrapment. That cop didn't force you to speed. He didn't trick you into speeding. He just didn't let you know that he was there to see you speed. Now, if he goes out there and is talking to you in the parking lot and he's like, man, I bet that thing can go 60. Let me see what it's got. Open it up when you get out on the road, and then you go speed. That would have a higher probability of meeting entrapment. But him sitting there watching you do what you do anyway isn't forcing you or tricking you into doing anything. He just isn't advertising that he's there looking for you. So entrapment, really the key to it is, are they tricking you into doing something that you wouldn't ordinarily do? An example of this would be a police officer. Let's say I've got a personal vendetta against you, and I just want to arrest you. And so I spend, 6 months trying to convince you to sell this little bit of drugs to somebody. Just so 6 months later, when you finally cave in to get me to shut up, you go sell this one bag of drugs, and then I arrest you. That would be entrapment. You're not a drug dealer. You're not someone who engages in that behavior. You only did it because I pressured you for 6 months to do it. That's entrapment. The last one we're really going to talk about is something called inchoate offenses. These are offenses where you didn't actually commit the crime, but you can still be held criminally liable. An example of this, probably the one you hear about the most, is attempted murder or attempted whatever. Let's say I'm going to kill somebody, and I go out. Let's say I'm going to go kill my wife, and I'm going to try to kill her, but I'm arrested before I can, or I am unsuccessful in trying to kill her. I didn't technically kill her. I didn't murder anybody, but I tried to. So it's an inchoate offense. It's basically, again, getting back to these complicated words, think of inchoate as basically incomplete offenses. Probably the easiest way to look at it in first pass is incomplete offenses. I didn't complete the criminal thing, not because I didn't want to, not because I didn't try, but because I was prevented from doing it. So, for instance, let's say I'm going to murder my wife, and I spend 6 months looking up poisons online, trying to figure out the perfect cocktail. And I go out and I buy all the supplies up, and I got everything ready, and I'm ready to go. And then the police pick up on it through, internet surveillance or whatever. They come arrest me. They can charge me because I attempted it. But key to that is, I can't be prosecuted for thinking about doing something. A lot of people think about committing a crime. You might have thought about, someday doing something. That's not a prosecutable offense. What makes attempt prosecutable is I took some physical steps to accomplish that goal. In my scenario, I went out and I actively took a step of researching poisons. I actively went out and took a step of acquiring the materials to make those poisons. And so there's actionable steps that the prosecution can then look at and say, look, he's attempting to kill this person. A next one is conspiracy. Basically, that means 2 or 3 people or more are working together to commit a crime. Another example would be someone who, let's say I want to get involved in the drug trade. Somebody delivers, someone sets it up, someone's part of the distribution chain. It's all a conspiracy. It's all connected together. Solicitation is another one. You see some in the news, many more sadly, where I'm trying to get someone to commit a crime. So let's go back to me wanting to murder my wife. I want to murder my wife. I don't want to do it myself. I want a good alibi. I'm going to go on a business trip. But I'm looking around. I'm trying to find somebody who's willing to kill this woman. So I go out and, I talk to some people, and people are normal human beings and they're a little bit weirded out by me openly trying to get them to kill my wife. They contact the police. The police set up a situation where I'm in contact with a police officer who I think I'm hiring to kill this woman. And then I'm arrested. Now, I didn't kill anybody. I didn't commit any actions except try to find someone to kill her, and talking to this person and getting them to agree to kill this person. That's called solicitation. I'm out looking for someone else to commit this criminal action for me. So I didn't actually commit it myself. I'm looking for someone else to do it. In that case, again, there's actionable steps that can be proven in court. I didn't just sit in my room and go, I'd like to kill this woman. That ain't what happened. What happened was I went out and actively looked and talked to people to the point that they called the police, and the police actually set up, and maybe I gave them money, but we set up the conditions under which this is going to happen. I took actionable steps that create criminal liability. With that, that's pretty much this week. If you have any questions, again, please email, text me. You've got my phone number. I hope you all have a great week, and let me know if you need anything.